Good morning. My name is Representative John Andrews. I represent House District 79 in Western Maine, and I am here today to speak about the lawsuit against Governor Mills, Speaker Talbot Ross, and Senate President Troy Jackson. There's something rotten in Augusta. Democrats have complete and total control of the House and Senate, as well as Blaine House. Majority Democrats even get to pick the Secretary of State, Treasurer, and Attorney General. Essentially, the Maine Democratic Party makes the law and interprets the law, all while being backstopped by Governor Janet Mills. This is why we have constitutional protections, to stop the abuses of a tyrannical majority. This is also why the concept of separation of powers exists. It's in the Maine State Constitution under Article 3, Section 1. The legislative, judicial, and executive are all separate and co-equal branches of government. One branch cannot tell the other branch what to do. These branches must function independently for our government to work. They must not bully other branches or collude together. Unfortunately, the latter is what we have going on in Augusta. The legislative branch and the executive branch colluded together to subvert the intent of Maine's Constitution. This is an extremely dangerous thing. So much so that I would call it a constitutional crisis. Representative Shelley Rudnicki, Representative Randall Greenwood, and the nonprofit Respect Maine are suing the governor, the speaker, and the Senate president in an attempt to find an answer to this constitutional crisis from the judicial branch. Respect Maine is a nonprofit dedicated to holding the powerful accountable and faithful to their constitutional obligations. The plaintiffs are represented by Carl E. Wook, Esquire, and Stephen C. Smith, Esquire. They are both under the banner of Steve Smith Trial Lawyers, and they come out of Augusta. Now, make no mistake, this suit is driven by citizens who have had enough of our powerful leaders in Augusta overstepping their authority. We've had enough of them breaking their oaths to the Constitution, and we are bringing them to court on it. All we are asking for is for Governor Mills, Speaker Talbot Ross, and Troy Jackson to respect Maine and her constitutions. Our suit challenges the constitutionality of the special session convened by Governor Janet Mills, arguing that it lacks an extraordinary occasion as required by the Maine State Constitution. Our founders pledged their lives, their fortunes, and their sacred honor to build this country and establish the rule of law based on constitutional restrictions and principles. We are not a monarchy, we are a constitutional republic, by and for the people, and that must be respected. The state constitution declares that there are rules by which our government must operate within to be legal. It is our duty as citizens and legislators to call out violations by rogue government and have the matter adjudicated in a court of law when the government violates the Constitution. And that is exactly what we are doing with this lawsuit. I thank you all for being here today, and I'm going to hand the mic over to Bill Clardy, who is the lead plaintiff in the case. Thank you very much.
All right. I just have a few points to address, no fancy speech. I started this lawsuit basically when I stopped looking for somebody else to do something, and instead I just took the first step and asked, who's going to stand with me? These folks said yes, and so did a whole bunch of others who are supporting this lawsuit. Second, this is political, but we're asking folks to look at it as nonpartisanly, look at it, listen, and judge as nonpartisanly as possible. We're not accusing the presiding officers and the governor of committing crimes. We're accusing them of betraying their oaths. And we're only asking the court to correct the wrongs, not to punish anybody. And as breathtaking as our ask is, which is basically to declare this session null and void, that's the minimum that will actually address the wrong. And we're trying to keep the court from asking them to do too much. And that's really all I've got to say.
As William said, my name is Carl Woke. I'm an attorney with Steve Smith Trial Lawyers here in Augusta. I'm one of the two attorneys of record representing the plaintiffs in this case, the other being Stephen C. Smith. And I don't have too much to add today, but I am here to give a little bit of legal perspective and for everyone's sake, keep it pretty brief and as not repetitive as possible, and also under 5 minutes because, you know, I bill by the hour. I'm sure I will have plenty of opportunities to make longer speeches in the courthouse, so I will save those for there. But in these brief remarks, I do want to emphasize that this is not a lawsuit between Republicans and Democrats. This is a lawsuit about the Constitution of Maine and accountability. It's about protecting those careful divisions of power among the three branches, as those same divisions protect the people of Maine from constitutional and governmental abuses. Now, the Constitution entrusts and quite deliberately divides lawmaking power between the legislature and executive power with the governor. If you cut through the constitutional legalese, legislative procedure, Latin phrases, and legal history, this case is easy to digest. Effectively, the majority party does not like the consequences of its own effort to shortcut a rule in passing legislation, so they invent a reason to exercise the governor's limited power to bring the legislature back to work. This is a sham, extraordinary occasion. And the Constitution does not lose its meaning when it becomes inconvenient to those in power. The majority party cannot bypass the rules in the Constitution or elsewhere, which they understand perfectly well, simply to take advantage of their legislative majority and continue putting their agenda into law. The key phrase that you'll hear today and several times further into the future is extraordinary occasions. These words matter. The text is clear. The governor does not have a discretionary power to reconvene the legislature, and political convenience is not an extraordinary occasion. Those words matter. They reflect important limitations on individuals in power, regardless of their party and regardless of the intentions of those in power, whether they're good or bad. Now, political accountability can come from the people. It can come in the voting booths. But when the stakes are this high and time is of the essence, we have to turn to the courts to hold the other branches accountable and to apply the Constitution as it's written. The plaintiffs are not here for political point scoring. They represent all Mainers who are interested in a government that plays by the rules, regardless of who happens to be exercising power, and who care about protecting the Constitution from political manipulation. I look forward to our day in court and to resolving this important issue on the merits. And with that, I'm going to turn to Representative Randall Greenwood of Wales, and then I'll be back to answer any questions that there may be. Thank you.
Good afternoon, and actually good morning, and thank you for being here. My name is Representative Randy Greenwood. I'm here from Wales, and I am one of the named plaintiffs and legislators in this suit. I'm the Republican lead on the State and Local Government Committee, and I support good government for the people, and that matters to me. That's why I'm willing to sign my name to this suit. I swore an oath to the Constitution, and I believe it is my duty to call out the powerful in Augusta when they violate the Constitution. I pointed out to the Speaker on the night we adjourned sine die, that night that we as a legislative body declared that our work was done and our session was over. My questions and concerns fell on deaf ears. The legislature adjourned the first session. The caucuses of both parties were polled as to whether they wanted to go into a special session. A majority of both caucuses did not agree to go into a special session. Just hours later, the governor, the executive branch, stepped in and ordered the legislature into special session. She can only do that if there's an extraordinary occasion. I hand-delivered a letter to the governor asking her what that extraordinary occasion is. Still have not received a response from the governor because there is no extraordinary occasion. Several times while acting as Maine's Attorney General, Janet Mills authored opinions that support our position in this case. As Maine's Attorney General in 2015, for example, Janet Mills wrote that the legislature alone determines when its session is over. In any attempt by another branch of government to reinterpret this decision might well violate the Maine Constitution. We are confident that the facts, the Constitution, and the law is on our side. We look forward to seeing the government in court for a redress of our grievances on behalf of the people of Maine. Thank you, and here I turn it over to Representative Reagan Paul of Winterport.
We have heard about the details and goals of this case. As we gather together today in the People's House, I'd like to challenge Governor Mills, President Jackson, and Speaker Talbot Ross to act in the best interests of the citizens of Maine. I'm calling on them to respect Maine, respect our people, and respect our laws. Let me be clear, this lawsuit is not about partisan politics. It is about doing the right thing for all Mainers. It is about principles, not party. It is about following the law and upholding the Constitution. We are committed to letting the courts decide the appropriate application and meaning of the law. We challenge the governor and the presiding officers to stand on that same ground, allow the case to be heard and tried on its merits, and not attempt to sideline us by playing procedural games. Please do not forget that we as legislators hold a sacred job. We were put here by the people to represent the citizens of Maine, not our own interests. We were put here to defend our oath and uphold the Constitution, and I take that seriously. We as legislators have a job to do, to serve the people of Maine, and the only way to represent each and every Mainer is by upholding the document that is the foundation of our state. We have a choice to make. Be governed by the rule of law, or be governed by the whims of man, or in this case, women too. Disrespecting Maine and its Constitution has become a habit of this administration, and it is time for accountability. The time to take a stand is right now. As a freshman legislator, I came in on December 7th swearing an oath with my hand on my Bible to uphold the federal and state constitutions. I was humbled but excited for the honor of my new role. But it took only minutes for that to turn into disappointment when the very first thing we were asked to do is violate the document we had just taken an oath to uphold by attempting to cut the citizens of Maine out of the legislative process. I was taught not to speak is to speak, and not to act is to act, and that is why I am standing now. You can be a part of the solution or a part of the problem, and I'm here to tell you that the Constitution is the solution. We as citizens of Maine have had enough of our leaders in Augusta disrespecting our Constitution and overstepping their role and authority. All we are asking for with this lawsuit is for those in power to respect Maine, respect Maine's people, and respect Maine's law. Thank you.
Any questions? Hi, Jackie.
I have a question. And if we could, put the legalese and the legislative vocabulary up to the side for just a moment.
Yep.
And explain to the Maine people why this is important. Maybe explain the difference of how the normal legislative process would work versus why it's an issue that the governor and the majority did what they did, calling a special session.
With no reference to the Constitution, or just in a very simple way? Yeah. No, it's important. It's important to ask that question because at the end of the day, we are trying to communicate directly to the people and why they should care. The Maine Constitution creates an incentive to have a bipartisan effort in, frankly, passing any legislation, turning any legislation into a bill and law by having 2/3 of the legislature vote to pass it, and then it can be enacted immediately. And for decades, that's how the budget bill was passed in Maine. What we've seen with this administration is, the Mills administration, is a effort to pass a partisan line budget, so you don't have the immediate effectiveness of that bill, and then artificially end the session so that their bill becomes effective. But in theory, that means the session is over. That's what the Constitution says. In this instance, what Governor Mills has done is, after passing the bill, after getting her bill enacted into law, even though it was partisan, and doesn't have the 2/3 majority that the Constitution endeavors to have the legislature pass, so that there is some bipartisanship, so that the budget reflects all Mainers to the best of its ability. The governor enacted or issued a proclamation that claims these circumstances are extraordinary, such that she can summon the legislature back to continue working, and that means so that the majority party can continue working on their agenda, running over the voices of any minority party that would not be a part of that agenda. So it's important to note the history and the structure of the Constitution insofar as it endeavors to foster bipartisanship and, building bridges, and again, representing the interests of all Mainers. And if what the Mills administration has done this year, what she threatened to do 2 years ago, if this becomes business as usual, we're losing that principle from the Constitution that endeavors to create bipartisanship. And ironically, if this does become business as usual, Governor Mills's so-called extraordinary occasion becomes all the more unbelievable. So I think what this group of plaintiffs is trying to do is ensure that there is an effort to continue fostering bipartisanship and passing important legislation in Maine, and also uphold what the Constitution says in order to preserve what the founders intended in terms of the operations of government.
So,
Can I stick in?
Do you want to?
I think I could give about a 5-sentence, at least my version of it as lead plaintiff. The safeguards in our government don't have neon signs blinking and lighting them up. And it's important to pay attention to them when you see them being slipped off, because I'm a military guy. I use military analogies quite a bit. You can pull the pin on a grenade, slide it in your pocket, and it doesn't go boom right away. But eventually you trip and bad things happen. So these are safeguards to protect our rights that the governor and the presiding officers have pulled the pin. And we want to get that pin put back in before it goes boom.
so just a follow-up to that. I think what you're saying, correct me if I'm wrong, I think the reason why the governor and the majority went this legislative route to dismiss the legislature and then reconvene under emergency, didn't that have something to do with lowering that threshold from 2/3 to just a simple majority?
Yes, it had everything to do with that.
That's, I think,
Right,
at the end of the day, that's
right.
the issue.
So it had everything to do with that. And
Sure. If with a 2/3 budget, it becomes law as soon as it's enacted. With a partisan budget, you need 90 days from the sine die adjournment until the end of the fiscal year, which is July 1st. So that to pass a partisan budget, they need to adjourn 90 days in advance of the new fiscal year. And that's what happened. They adjourned us early to meet the 90-day threshold. And then the governor ordered the legislative branch back in under a hazy and, extraordinary occasion that nobody is really sure if it actually exists, which is why we're bringing the case.
Can I ask you a question about, I feel like when the adjournment, also I apologize. When we adjourned after the 2/3 budget, there was, still public hearings that were scheduled for the following day, and I think I was looking for legislators who weren't here. I think there was a little bit of confusion. Can we talk about, I don't say chaos, but can we talk about the problems that adjourning like that caused for the legislators?
sorry, yeah, and you said 2/3 though
Oh, no,
after the.
simple, I'm
the simple majority? Okay, yeah, and there are, when it comes to like the legislative business, I do defer to the people who are actively here. So again, if you want to do, yeah, I don't know how we're doing that.
Could you repeat your question, Jackie?
Yeah, so just, I feel like there was a little confusion. There were public hearings scheduled for the next day, but there was an adjournment, so a lot of people didn't.
Sure. So I think there was chaos because for each session, the first and second, there's a statutory adjournment date. For the first session, it is June 21st. So we have from the first Wednesday in January to June 21st to get our work done. Adjourning us extremely prematurely kind of opened Pandora's box for a bunch of unexpected consequences. So they said we had committee the next day, even though the session's over. That didn't make a lot of sense to a lot of people. And on top of that, the speaker tried to slide through a resolution last week under the hammer, asking the Maine Supreme Judicial Court to answer questions about the legality of referendum questions that are supposed to be, specifically dealt with within the first session. Well, first session's officially over, we're signed to die, but now we have referendum questions we need an answer to. And the governor cited nominations in her proclamation, but within the Constitution, the Senate can call itself in to do confirmations. That's in the Constitution. So her main point for the extraordinary occasion is fairly moot. And again, I think adjourning so prematurely with no real action plan to give a heads up to what's going on to people is why we had so much confusion.
What have you guys heard from constituents about adjourning prematurely?
I think the big takeaway is that people are not happy that the Democrats rammed through a partisan budget. My district leans a little bit to the right, and they were not happy about being disenfranchised, not having their voice matter when it's just a majority budget coming primarily out of Portland and Bangor. It's a giant state with a lot of opinions, and I think we need to allow the people who are represented by every town in this state to have their voice heard, collectively on a budget. And historically, I think that's why we've had two-thirds budgets in the past. This is the first time in Maine history under the Mills administration that we've had back-to-back partisan budgets. I think previous to that, there was one in the 90s, and I think they tried one under Baldacci, but it didn't go anywhere. So partisan budget was an extraordinary occasion every now and then because it never happened. But now it seems to be becoming the status quo. And that's what really worries all of us up here. If you zoom out and you see they did it once, they did it twice, third time, that is a consistent pattern in the new operating procedure. It's widely unconstitutional, and that's why we contacted council, because we think we're all digging into our own pockets to pay for it because we think it's that important. It's a fight we need to pick to be faithful to our oaths to the Constitution, and we're very happy to have Mr. Wook representing us.
And tell me about that partial budget.
Go ahead, Jackie.
Oh, no, is there I did some research on this one happened, so I was kind of confused about why they adjourned, what's going on.
Sure.
So,
It's a confusing subject.
Yeah. It looks like, the first one that's happened was in 95 or something. It's a rare occasion. Is there a fear, now that it's happened back to back, is there a little bit of a fear that it will continue to happen even under, a Republican governor?
100%. I mean, that's why we retain counsel and are bringing a suit. I don't care who has the majority. I don't care who is governor. The whole reason why we have a constitutional republic is because we have constitutions, and constitutions they're not restrictions on the people. They are restrictions that are placed upon government, saying, government, okay, you will operate within these boundaries. And when you step out, it's the duty of people who swore an oath and the duty of concerned citizens to step up and say, hey, we need to take this to court because you're breaking the Constitution. We cannot allow this to go forward without, a full redress of grievances from the judicial branch.
What do you hope the outcome is of this lawsuit?
The perfect outcome would be a definitive ruling from the judicial branch as to what exactly is the definition of an extraordinary occasion and what should be the process going forward. What are the powers of the executive branch to call a special session? What are the parameters of adjourning early and the impacts thereof? How does that impact referendum questions? How does that impact committees meeting? How does it impact budgets? We're going to the judicial branch for clarity because, in the three branches of government, they're pretty much the referees. They're supposed to be fair and neutral arbiters, and I'm sure that they will be. And we are just looking for a definitive resolution to this constitutional crisis.
Was the legislature officially called back after the adjournment?
Well, so here's what happened. They adjourned, signed a die. then to call a special session, each political party's caucus needs to be polled, and you need to get a majority of the membership of each political caucus to agree to go into a special session. That did not happen. A majority of both caucuses were not in favor of going back into a special session. That's when the governor stepped in and told the legislative branch what to do. That's when the executive branch told the legislative branch what to do. And that's what's unconstitutional, and that's why we're bringing this suit.
Have you heard from President Jackson, Speaker Talbot Ross, or Governor Mills yet?
I have not, but I'm very excited to see them in court. All right, thank you.
As Jackie was kind of getting to it, this is for the attorney.
There you go.
Happening.
Could you give us maybe a 30-second or 60-second crash course into what exactly is supposed to be the mechanism that triggers that emergency session power from the governor?
Well,
Because now that we've had it last time, now it's almost like whatever the political party that's in power, that their cause rises to that standard. And is that the case? Can you kind of just educate us on it?
your questions always put a bind on my ability to answer them, but what we know about this language.
120 seconds.
Sure. What we know about this language is that it is clearly not a discretionary power. And I can get into the weeds on that. But fundamentally, there are constitutions, including the Massachusetts Constitution of 1780, that allowed the governor to reconvene at his discretion. Maine did not adopt that. Maine says it has to be a extraordinary occasion. The judiciary hasn't told us what constitutes an extraordinary occasion. That's really what is the gravamen of this lawsuit. We need to know, because if it's going to be subject to what amounts to discretionary abuse by the governor, if whatever the governor says constitutes an extraordinary occasion, then those words are meaningless. And the legislature will serve at the whim of the governor. And that fundamentally violates the separation of powers principles that are embedded in the Constitution. So that's really what it comes down to. It's important, again, to emphasize this is not a lawsuit between Republicans and Democrats. This is about the Constitution, and it's about accountability. And whether the party in power has a D or an R, at the end of the day, the plaintiffs here are interested in fundamentally ensuring that the Constitution is respected today, March 30th, and going forward in the future.